Hello, everyone. My name is Gabriela Zanfir-Fortuna. I am, there we go. Welcome. Thank you so much for joining me for a panel that the Future of Privacy Forum organized. I am Senior Counsel for Global Privacy for the Future of Privacy Forum, a think tank based in Washington, D.C. And I am very happy to host today a discussion about the wonderful things that are happening in the world of US privacy law and US privacy lawmaking and policymaking. I have crossed the Atlantic in 2016, just after the GDPR was adopted, and I was very lucky to actually witness what kind of impact the GDPR had here, primarily and first of all in companies that were offering services in the EU and that had to change their accountability processes and change how they are collecting and using personal data. But then I also saw some other type of influences. And I still remember when I was reading the draft California Consumer Privacy Act, I was recognizing some language from the GDPR. However, I could also see that this only played a role to some extent. And there are a lot of cross currents that are happening here in the US that actually lead to very, very significant developments of how citizens are looking at privacy here and other changes in lawmaking and policymaking. We have seen many developments at state level, state legislation that has been proposed. Only this year, we have seen bills of comprehensive privacy law proposed in Virginia, for example, or New York. And in Washington state, there's already the third time that legislature is debating a comprehensive data protection law to probably pass this year. But in order to debate that, and also all of the very interesting developments we've already seen in California, and all of the privacy bills, comprehensive privacy bills we are seeing at federal level, I've invited a panel of experts, and I am so much looking forward to hear from all of them. So we are lucky to be joined today by Stacey Schesser, Supervising Attorney General for the Privacy Unit in the Consumer Law Section of the Office of the California Attorney General. So one of the most recent privacy regulator here on this side of the Atlantic. We are also lucky to be joined by Lydia Parnes, who is the co-leader of the privacy and cybersecurity practice of Wilson Sonsini in the Washington, D.C. office. And Lydia is also the former director of the Bureau for Consumer Protection at the Federal Trade Commission. We also have today with us Jared Bomberg, who is senior counsel at U.S. Senate, the Committee on Commerce, Science, and Transportation, and he's working for Senator Maria Cantwell, who led the proposal of, I would say, the most comprehensive and the most protective privacy bill, but that's absolutely a personal opinion at federal level here in the U.S. And then last but not least, we have Professor Anupam Chander, Professor of Law at Georgetown University, who is an expert on the global regulation of new technologies, has written extensively on data localization, and has practiced both in the US and Hong Kong, which I found very interesting as a point of trivia there. To start the conversation, I will go first to Anupam. Anupam, what are the biggest, most consequential developments we've seen in the past 4 years in US privacy law?
So if I were to name 3, I would suggest, of course, the CCPA passed in 2018, and also then judicial development, Carpenter v. United States, also in 2018, a Supreme Court decision. And then, of course, the CPRA passed by initiative in California in 2020. So those 3 taken together do really mark a new era in US privacy law. And I think they will define what we will see over the next decade The California law establishes a baseline that effectively becomes a kind of de facto national law. The California Attorney General becomes essentially the privacy regulator for the country, for good or bad. And I certainly think it's not an ideal way of managing that issue. And the judicial intervention, the Supreme Court's 5-4 ruling in Carpenter, really gives us more of our privacy back, because it says essentially you need a warrant based on probable cause that a crime has been committed before you can obtain geolocation information, location information from third parties who have information about where you are, at least if that information is for a period of 7 days or more. There's a slight footnote in that, in footnote 3 in Carpenter, that says our current opinion deals with, we clearly know what we think about collecting information about where you are for 7 days or longer. That requires a warrant. We don't know what happens for 6 days or less. In any case, all 3 of those moves really change the nature of US privacy law. The judicial intervention really also shows us that the Supreme Court has an understanding, and we've seen that in a number of opinions over the last now 2 decades, that technology should not be allowed to erode our protections of privacy against the US government. And so the Fourth Amendment has been interpreted by the Supreme Court to really say, if you are using a kind of doing a technological equivalent of a search before that we would have found to be required to be subject to a warrant requirement, the technological equipment is also going to be required to be subject to a warrant requirement, at least, with that 7-day caveat that we can identify. And the CPRA, of course, is also critical because it shows, I think, not only that there is a new, stronger, now a data protection authority in California that will come online in a couple of years, but it shows that there's such a huge appetite in the public for data privacy law. The opponents of this initiative argued that the bill was not strong enough. That was the principal argument of the opponents of the CPRA. I personally think it's a terrible way to make law in the initiative process. So I was against this because the initiative process is not the way we should be regulating privacy. There is a huge appetite for privacy law, as the initiative demonstrated, and we could have obtained this through legislative means. So in any case, I will turn it back to you, Gabriela.
Thank you so much, and I'm quite not surprised, but actually I'm happy to hear that 2 of the 3 most important developments are actually related to what happened in California, where we saw the first comprehensive baseline. Some friends would call it privacy legislation. It applied across industries, and it has strong consumer rights and so on. I will move to Stacey now, because she has been at the forefront of what was happening in California in the past couple of years. Stacey, what were the improvements that the CCPA brought to the privacy rights of Californians? And also, what are you seeing in practice? It has been already applicable for 1 year. Are you seeing some changes in business practices? Are you seeing increased interest in consumers to submit requests? What's happening in California? Unfortunately, we cannot hear Stacey. I'm sorry about that. There seem to be some technical issues. Yes, so let's, well, I was hoping to hear now about California because it's just so important what's happening here. But I'm also happy to move already to federal level. Perhaps giving our primarily European audience a bit more flavor of what's happening at state level. So we have this baseline comprehensive privacy law in California that was adopted in 2018 and became applicable last year. And then we have the CPRA that Anupam just talked about. However, in the rest of the US, we have many other bills that are being considered at state level by state legislatures, some of them more serious than others. But then what's happening at federal level? And Jared, please tell us, what are we seeing there? There's a lot, there has been a lot of activity. I've counted at 1.30 bills that had the word privacy in the title.
Sure, I'm happy. I won't be able to describe all 30 bills, but you know, let me say that I think Anupam's characterization of some of the big forces working to push the Congress to put in place comprehensive federal privacy law are right. And Stacey would have gone through the activities in California, which are very important. And I'm not going to try to summarize all of them, but when CCPA passed, it included a few different rights for consumers, notably access and deletion rights and opt-out rights. Those rights are similar in many ways to GDPR rights, but not nearly as comprehensive. The CPRA will extend those rights even farther to rights of correction and also some business obligations related to data minimization. And I say all that because that more comprehensive package is what the Congress has been focused on pretty intensely for the last couple of years. As Gabrielle mentioned, I work for Chair Cantwell of the Senate Commerce Committee. In that role, we look at commercial privacy regulation as opposed to, say, writ large. So across industries for the most part, with some exceptions related to healthcare and financial services, which are regulated under sectoral laws. And we also don't necessarily cover the national security laws that Anupam was referencing in the Carpenter decision. But it's all to say that Congress has been intensely focused on a comprehensive law, and there are a number of different approaches. I would say that maybe the two of the leading approaches in the Senate, at least on the Commerce Committee, is one authored by my boss. And it's called the Consumer Online Privacy Rights Act. And the second is authored by the Republican ranking member, Senator Wicker from Mississippi. And it's called the Safe Data Act. Both bills have a number of co-sponsors. And for anyone who's watched the debate closely, there's a lot of overlap between the bills that I'll go through and note some of the differences. But then just to give you a sense of the scope, there are other approaches out there in Congress. There's some members who want to create a fiduciary duty model. So something much more basic in one sense, but that creates obligations on businesses to protect the data in the interests of their consumers or the users of their services, similar to fiduciary models under US law in the context of, say, a doctor-patient relationship or a financial services arrangement where the caretaker of your funds has to work in your interest and not their own. And then there are some members who would like to see more of a GDPR model that creates a strict set of allowable processing activities, and then a number of exceptions to those activities. And so I think the Congress is still at the point where it's working out where of this menu of options, which options it's going to take up. But let me focus, if I can, on my boss's bill and Senator Wicker's bill. And I'll try to run through the similarities and differences pretty quickly, just to give you a sense of where some of the bigger disagreements are. I think there's a lot of commonality around rights, so access, correction, deletion, portability. There's less commonality around enforcement. Areas like the FTC's ability to enforce the law, which is the sort of main general privacy regulator, is an area of similarity, but Senator Cantwell's bill empowers consumers to enforce the law in court. Senator Wicker's bill does not. And Senator Cantwell's bill allows for states to continue to serve as, quote unquote, the laboratories of democracy, as Justice Brandeis coined in nearly 100 years ago. And so that disagreement about enforcement is a pretty big gulf that we're working through. There are other substantive areas of disagreement with respect to how civil rights is handled, to the extent to which there's algorithmic transparency and accountability, and issues related to dark patterns and how consent may be forced. So happy to talk through all that in more detail, but I think just to give maybe a final overview of where I think we're at is, 10 years ago, 12 years ago, there was a push for do not track legislation, and that was considered the comprehensive solution in the US in many respects. And in looking back, we can see how narrow we were focused at that point. Over time, there's been a scattershot of bills, and some that have passed and others that haven't, that have helped inform the sort of the contours of a broader privacy bill. And the passage of the GDPR and CCPA have further sort of informed the Congress on the ways in which to best balance these interests. And so we've moved from a scattershot approach to a comprehensive approach. I think many stakeholders have been analyzing these laws, so we're sort of in the analysis portion now of the comprehensive bills before us, and hopefully we'll get to the consensus point sometime soon.
Fantastic, thank you so much. And since we, I will come back to you in the second round of questions for maybe some prediction of chances of seeing a comprehensive federal bill. But let's see if Stacey, we can hear Stacey now.
Hello, good morning.
Yes. I'm so happy to hear you. And thank you for joining us from California, where is actually even earlier than here on the East Coast for our audience in Brussels. So we just were talking about how important California was in this boost for comprehensive baseline privacy legislation in the US. Tell us a bit about your experience in implementing the CCPA, and what type of changes have you already seen in business practices and consumer behavior?
Sure, thanks so much for having me again, and sorry about the technical difficulties. This pandemic keeps providing all the more fun stories to tell at the end of the week after we've survived them. Again, I'm just going to give the typical disclaimer. The views that I share here are my own, and I'm here on behalf of the Attorney General, but I'm here right now speaking on behalf of myself. So I think that, in 2018, when CCPA sailed through the California legislature in 1 week, there was a big ground shift. There was a change in how privacy was now going to unfold. And since January 1st, 2020, when the law became effective, we have seen companies grapple with really interesting.
I think we have again audio issues. Operator. We try again. This is as my boss said earlier. We understand more and more the trade-off between utility and some privacy. If I can be afforded a joke, and we move to Lydia. Lydia, I was wondering what your experience has been in the past 3 years or so. You have been advising companies on GDPR compliance, but you have also been advising on CCPA compliance and on other, I would say, privacy regimes around the world. How have you experienced this new wave of law coming to the US? And do you think that companies, in a way, are prepared to face federal privacy law, perhaps, a bit better than they were 3 years ago, thanks to the GDPR CCPA experience?
Thanks so much, Gabriela. I hope everyone can hear me. And yes, technology in the pandemic world is certainly challenging. So the short answer to your question about whether companies are ready for comprehensive federal privacy legislation, I think the short answer is yes, they are ready for that. And that comes with a caveat, though, that I'll address in a moment. Gabriela, as you know, we have been very busy advising companies on compliance with the GDPR and more recently with the CCPA. Candidly, GDPR back in 2016, that came as a real shock to most U.S. companies. In large part, I think because the privacy framework that was set up by the GDPR is so different than the framework that operated in the United States. But, companies of all sizes have paid attention to the GDPR. They have devoted very considerable resources to their compliance effort. And I think it's the laws really had an impact on the way in which businesses of all sizes operate with respect to consumer data. And just as, kind of some examples, data mapping, which is, kind of a basic exercise that companies engage in for GDPR compliance efforts, that's given companies much greater insight into the data that they actually collect and force them to look at why they collect it and how they use it and how long they need to keep the information. And certainly the legal basis that they have for collecting it. And companies have set up processes for consumers to access, report, and delete their information. And many companies have decided to apply some or all of these GDPR compliance efforts on a worldwide basis. So, in terms of federal legislation, I think there are a host of reasons why companies in the U.S. have really come to support privacy legislation. To some extent, GDPR has set a compliance mind for many companies. Added to that, some U.S., there are many U.S. companies now have to comply with the CCPA. and it applies to most, if not all, online companies in the U.S. And as we've heard, other states are following California's lead, and industry is facing the prospect of having to comply with dozens of state laws, all regulating the same practices, potentially in slightly different ways. And I think this has all contributed to industry support for federal privacy legislation. But I think there are like two caveats, and this is where we've heard that there's some disagreement on the Cantwell and Wicker bills, and that's on federal preemption of state law and whether there'll be a private right of action in a comprehensive federal privacy law. These are really key issues for companies. I think that passing a bill that preempts state law, I hope I'm wrong, but I think that will be a challenge. But I think that it really is, I think without preemption, a federal law becomes potentially the 51st privacy law in the United States, and not something that's a unifying factor. I think that if Congress is able to get over those two big issues, preemption and private right of action, I think reasonable people will be able to have good debates about the substance of what this law should look like. And I think that there will be pretty uniform support for
Thank you so much. That's all of those are actually so important points that are at the core of the privacy legislation debate here in the US. Let's try again with Stacey. Can you hear us? It is still not.
I can hear you.
We can hear you too.
Can you hear me? Yeah, this is a whole different computer. We'll see if this works.
And CCPA.
Morning. Yes, okay. I'm going to talk fast, so let's see what happens. It's a good thing I'm from Jersey originally. Okay, so what we've seen in terms of how CCPA has impacted folks from California and across the country, because again, California is 20% of the United States population, as well as the 5th largest global economy. And so we are home to many, many businesses that have to fall within the compliance and the enforcement arm of CCPA. On the consumer side, we've seen a lot of consumer awareness. We've seen consumers embrace their rights, try to effectuate their rights, and also at times get very frustrated when they think that they can exercise their rights, and unfortunately, it doesn't lead them to a place where their expectations meets where the law aligns. I think one of the areas in which CCPA, for example, has frustrated consumers has been
Okay. I apologize so wholeheartedly to Stacey, especially that I know how early it is for her. But at least we got to hear how important and relevant the developments around CCPA are for 20% of the US population, and we got to hear about how the attitudes of consumers are changing. I would also like to say for our audience here that we speak of consumers, right, under the CCPA, but in fact, the consumer is defined so broadly that it really refers to individuals, like a natural person that is a resident in California. The person protected doesn't necessarily need to be a consumer in the traditional sense. This is one important point to make for our friends in Europe. Anupam, I will move back to you now, and I know that you actually have a hard stop earlier than the end of the panel, so I would ask the audience to be forgive us for not having you here for the Q&A section as well. I was hoping that you can tell us, where do you see the US in the broader global conversation? We know that it's one of the countries that, one of the very few countries that does not yet have a comprehensive privacy law. But look, a lot of things are happening.
So I think the United States has failed to maintain its leadership, its thought leadership on technology issues. And I think this is evidenced in its failure to establish a national privacy law. And what you're seeing across the world is countries borrowing the example of Europe and not the United States. The United States tried to kind of promote the APEC framework, but that has not yet been wildly successful. And instead, what we've seen across the world is countries embracing principles from the GDPR. This includes China, Nigeria, India, Brazil. Those are very significant players to be turning to Europe. Now, of course, that is in part driven by a kind of quixotic attempt to achieve adequacy, and so a ruling that is unlikely to be delivered in their favor. But in any case, be that as it may, Europe has turned out to be the thought leader on data protection issues. I agree with Jared that there are a number of different approaches to how to protect information, how to protect individuals, people. And it's not clear to me that the GDPR has it precisely right. And I think there needs to be further scrutiny and debate on these questions. But the United States, by failing to adopt any national standard, I think has ceded leadership to Europe. And now I think what you're seeing is other countries that are going to also try to innovate models and innovate in enforcement. I should note that, whatever the law in the books is, the U.S. has been a leader in enforcement, and we have, already under the CCPA, huge numbers of class action lawsuits have been filed. There have been settlements already, and obviously with respect to security breach provisions that have a private cause of action, and obviously of the FTC and lots of privacy-related causes of action that we've seen over the last 20 years. So I think there's, the United States has, unfortunately, however, failed to keep up with the regulatory infrastructure directly. And I think that is evident as other nations look to Europe instead.
Thank you so much for those comments. And perhaps just before you go, there is a question that I think you can address, Anupam. There is a question from one of our attendees. And they are asking how feasible, Sarah is asking, how feasible is global or EU-US harmonized privacy legislation? What are the largest barriers to that?
Well, the Schrems decision, of course, requires the US and Europe to come to another modus vivendi. The Privacy Shield is no longer, the Schrems II decision, I should say, the Privacy Shield is no longer, and we're going to need yet another device to allow for interoperability between the European privacy law and the American privacy law. And I think that it's quite possible to achieve. The complaints in Schrems II were really focused not on our privacy law. A national US privacy law actually wouldn't solve the Schrems II problem. Instead, it's focused, the Schrems II decision, as the Europeans in the room are all very well aware, is focused on the absence of rights of action by Europeans who are surveilled by American intelligence services. That, I think, can be solved. and I think it should be solved. And so I do think that it's possible to achieve. The Privacy Shield itself had a lot of mechanisms that showed promise for actually achieving privacy. I've talked to a lot of lawyers who tell me that the Privacy Shield, which is subscribed to by a few thousand American companies and European companies, was really taken very seriously by those companies. And they've really put in a lot of work to protecting the data according to those rules. That suggests that there is a way to achieve a kind of an agreement between these two huge powers. And I hope that is a model for agreement in the future as well.
Thank you so much for those remarks and for joining us. And I'm sorry we cannot have you for the final part of the panel.
Thank you.
And since should we try Stacey again?
Stacey, do I have you?
Yes, I can hear you through the phone.
Can folks hear Stacey?
Yes, Jared, that's brilliant. So we will hear Stacey from Jared's speaker and see her here. Thank you so much for quickly thinking of this. You will solve this federal privacy legislation conundrum, Jared.
If it was only that easy.
So much collaboration. I think that's a good thing, right? Okay, so I'm pulling up my notes 1 second. So I think where I had left off was discussing the fact that we've seen consumer awareness, but also some consumer frustration. There's times at which consumers expect that they'll be able to delete all their personal information, for example, from a business, but because of the multitude of different exceptions that CCPA provides for, often that's not really met with what their expectation is. I think another area in which consumers sometimes are feeling frustrated is in how the right to opt out functions. And I think part of that is that, trying to figure out, first of all, if a business has interpreted the CCPA in terms of if they are selling personal information. So as folks should know by now that the right to opt out only applies if a business is selling personal information. And so a business is required to disclose that it's selling personal information. But that definition is very broad, and businesses have taken varying approaches to how to interpret what sale is. And so consumers are trying to find the opt-out link and trying to figure out ways to communicate with the business to fully say, don't sell my personal information. And there's been studies that have been done to date about how that's not always as conspicuous or clear as the law, I think, intends. From a business side of things, from a business compliance side, at first there was a lot of, I would say, businesses feeling like it was a very overwhelming undertaking. Complying with CCPA went beyond where companies who had complied with GDPR had to, do a bit of a work involving a delta for figuring out what their compliance obligations were on top of GDPR. And then because there are some companies that did not have to comply with GDPR, those companies had to start from scratch. And so I think a lot of businesses know that is a significant undertaking. But what we're seeing and what it's resulting in is greater transparency, updating privacy notices so that it discloses what practices are, companies doing data inventories and data mapping and trying to really figure out where the data flows are. That I think is heartening as a regulator, because I think that shows that companies are really taking what their legal obligations are seriously. So, now that we have been enforcing the law since July 1st, that's when the statute granted us enforcement authority, we had hit the ground running. I think that there was a bit of surprise on July 1st when notices went out to companies. There was, I enjoy looking at, for example, I enjoy looking at Twitter, and there was a bit of a shockwave that you could see within the privacy community. that there was surprise that notice letters had gone out on July 1st, when in fact the Attorney General had been very public about saying over and over, we are going to be enforcing this law as soon as possible. And so, what we have seen since July 1st, and we have sent out, many of these notices, I would say we're well into the double digits at this point, is what we've seen is that companies are coming into substantial compliance. We cannot disclose any confidential investigation. And so even, the process of investigating a company and sending a notice letter is what we would deem a confidential investigation. And the point of that is to, ensure that companies are cooperating with us when we're in the process of investigating. And if they do come into compliance with the law, then there's really nothing for us left to enforce. And so the notice and cure period, there's a requirement in CCPA that notice is given and there's 30 days to cure, has really yielded what we've seen companies coming into compliance. And I think that, that is what the law intended, and many of the conversations that we're having have, in my mind, have been positive, because I think that companies have received our notice, taken what we've alleged seriously, and made changes. So, in addition to just enforcing the law, we're enforcing the regulations. We are nearly done with our last bit of this initial rollout of regulations. We had just closed out one last small round of regulations, and so, for example, those touched on, I think I caught Jared talking about it earlier, enforcing against companies that use dark patterns, for example, to try to subvert a consumer's choice. And so now, with enforcing both the law and the regulations, and that is what will be in effect until CPRA takes effect in 2023. We definitely have our work cut out for us.
Wow, thank you so much for that. And I think it's so relevant to telling the world that there is a new privacy regulator in town, right? A very serious one, the Attorney General. And this actually brings us to the conversation on enforcement, right? And I would go to Lydia now to drill a bit more down into the conversation on enforcement of privacy law here in the US before moving to Jared. So Lydia, you've worked for the FTC for a long time, and we've seen some very serious action from the FTC in the past couple of years, and some very innovative ways of enforcing consumer rights and privacy rights as well. Only last week or so, in one of the orders of the FTC, an app was forced to also delete the algorithms and models that were created on the basis of images and other data that were unlawfully collected. So that was quite interesting to see. Besides the $1 billion fine that we've seen last year or a couple of years back. So how do you see the role of FTC in this? And if you could perhaps also touch a bit on this, the idea of attorneys general, being enforcers, or a federal agency like the FTC being enforcer of privacy law. What are your thoughts on that?
Sure. Thanks, Gabriela. Well, I was actually glad to hear that Jared said that there was agreement among Senators Cantwell and Wicker that enforcement of a comprehensive federal privacy law should be vested in the Federal Trade Commission. I certainly agree that that's the place it should be. And the Commission has been quite aggressive in its enforcement over the past several years. I think that we'll see more of that with the incoming administration. Commissioner Rebecca Slaughter, who becomes the acting chairman in just a few days, has signaled over her the past few years as a commissioner. She's indicated in speeches and in concurring and dissenting statements that she's issued her support for very aggressive enforcement. So, just as a couple of examples, she supports the use of civil penalty authority in privacy cases. That would require the commission to either engage in rulemaking authority on its own or to get that authority from Congress. She supports the greater use of FTC rulemaking authority in consumer protection cases more generally. And again, if the FTC is enforcing a rule, it can get a civil penalty. She's willing to hold top executives personally liable if warranted. And she's actually pushed staff to broaden their investigations to determine whether individual liability is appropriate in individual cases. And the staff, of course, takes that very seriously. So, I think that we will see kind of additional aggressive enforcement from the commission. I would note the FTC has a long history in this area. They've been doing privacy enforcement for 25 plus years, and in the absence of federal privacy legislation, have been using Section 5 kind of fill the gap. So the commission has held over the years dozens and dozens of workshops with stakeholders and issued very fulsome reports addressing a host of privacy issues and basically setting out recommendations for industry that have become baseline norms for companies to follow. And again, the cases that they've brought don't just affect the individual company that's subject to the order, but send a message to industry at large in terms of enforcement. So I think the FTC has been effective, has been quite aggressive. I appreciate the work that the folks in the California Attorney General's office have done, and I think that there is a place for state enforcement of a federal law. The model that's been used in so many instances where the FTC has been given enforcement authority is FTC is given authority to issue a rule that's enforceable both by the commission and state attorneys general. And I think that is the proper model to use here. I think that as many people have said, the commission has limited resources, and engaging the resources at the state level would be a very effective way of enforcing a federal law. So I think there's a place for both.
Thank you for those comments. And indeed, enforcement is actually one of the most contentious points right now at the federal level, but also at state level, where we're seeing debates in Washington state, and we're seeing privacy advocates opposing the passage of the entire act that would actually give protections to individuals in Washington state, because it doesn't have a private right of action. So they would actually throw away all of the other protections just because that private right of action is not in this rendition of the bill. Jared, the next question is for you. What are the debates at federal level? Should enforcement belong to the FTC or not? What's the proposal in the bill that you contributed to? Should a new agency be created? Should we consider this model that Lydia was just presenting, with some enforcement at state level by attorneys general? What are your views on this? Where is the debate right now?
Sure. So the area of biggest agreement is that attorneys general should have a role to supplement the work of federal enforcement. So I don't think anyone has disagreed with that. I think people have pointed out, and Stacey's on the phone, she can speak to this as well, that the states have very limited resources. And even the Attorney General in California, which has one of the more experienced and bigger offices, said they could only bring 2 to 3 cases potentially a year. And that's going to be significantly more than the vast majority of states. So there's agreement that the AGs can play an important sort of collaborative and supplemental role here, and in the absence of federal legislation, the leading role. Where there's moving towards disagreement, I would say, is on what who the federal regulator should be. There is, in my boss's bill and Ranking Member Wicker's bill, a nod to the FTC continuing to serve in that role, in the way that, building upon 100+ years of consumer protection work, we think that there is, or the culprit takes the position that the FTC has an important role to play going forward, provided it has the right resources and authority. There are other members who would like to see a whole new agency stood up, similar to the way that Congress stood up the Consumer Financial Protection Bureau in the aftermath of the financial crisis in 2008, 2009. There is, and so the leading proponent maybe of that model is Senator Brown. But in terms of the work of the Commerce Committee, which has general oversight authority over commercial privacy matters, there's relative agreement that the FTC is the right place for a federal enforcement body. That said, the area of biggest disagreement, and there's also agreement, I think, to some degree, that the FTC needs significantly new resources, significantly more resources to carry out this mission. The area of biggest disagreement is obviously over private right of action. And COPRA, my boss's bill, takes the position that a private right of action is needed. It's needed because of the limitations on regulators, their funding constraints, and their broad missions. It's needed because standing rules in the US make it very difficult for plaintiffs to bring privacy cases and have courts hear those cases. You have to show that there's been injury in fact, it's concrete, and many courts have taken the position that the loss of your data isn't necessarily a concrete injury recognized by the court. So those cases get thrown out. Even in the data security context, there's a court split over when your data is stolen, whether or not you've suffered a harm. If you can't show that you've taken, that you've had some sort of identity theft that you've dealt with, or you've taken concrete actions to, deal with emotional harm or reputational harm, or spent money to protect your identity online. So even in cases of data security where there's an unauthorized breach, the courts haven't all uniformly been for seeing those claims play out in court. So that's to say that we have limitations at the enforcement level by government enforcers. We have constitutional constraints that make it quite difficult for plaintiffs to bring actions. And then you have market constraints as well that limit the ability of consumers to fully protect their rights. And to that end, I'd put in, as an example, maybe click-through agreements. Consumers are consenting away their rights all the time. And add to that list dark patterns. Consumers may not know what they've consented to. And so the lack of transparency and the power dynamics have created a situation where consumers don't necessarily understand what they've signed up for, but at the same time, those, every time they've clicked I agree, it's a defense a company can use against them in court. So that's a long-winded way of saying that you know, at the end of the day, consumers who have a claim and have had their privacy violated in a way that they can show that there's been some harm to them, it's the belief of COPRA that they should have access to enforce their rights in court, because they may not have them otherwise enforced. Now, I would say one of the biggest points of controversy is, well, isn't this just going to create a conflict of law? Aren't we going to have a judge in Alabama deciding the privacy rules for the country? And to that, I'd say we should look to see what the Congress has done on privacy matters over the last 30 years. And in many, many cases, privacy statutes in the US, include private rights of action. And we haven't seen the parade of horribles or the sky is falling arguments play out necessarily in that way. I don't want to paint a picture here that that there are lines in the sand and that a private right of action, a full private right of action is the only way forward. I think that there are lots of ways to talk through enforcement and the substantive provisions of the law. And the Congress is going to have to grapple with how we balance both the substantive provisions as well as the enforcement provisions. And there's lots of ways to skin this cat. So, we're looking forward to, in-depth talks on the scope of a private right of action alongside the scope of hopefully very strong privacy protections.
Thank you for that brilliant overview. And to translate a bit for our European audience and for our audience from around the world, when we are referring to a private right of action, we are referring to what in the GDPR we have as an effective judicial redress, a right to go to court, for any breaches of the law and submit a claim to a judge. This is actually a quite important matter, as Jared was just explaining. In California, in the CCPA, it was addressed by only allowing a private right of action for data breaches. And almost all of the other weight of enforcement was left to the Attorney General. And if we still have Stacey via Jared's brilliant hack, I would go and ask her, how are the powers of the Attorney General when enforcing the CCPA? What of the powers you've used most? Can you issue orders? Can consumers directly submit a complaint to the Attorney General? I think it's important for our audience to understand a bit how enforcement is working in the CCPA. And I'd like to add that, I think the California Attorney General is the only privacy regulator enforcer in the world that's actually directly elected. So, for sure, there's independence there.
Sure, I'm still here.
Go ahead, Stacey.
Oh, sorry. Yeah, so I think that there's already been such interesting points made by both Lydia and by Jared regarding, both the work of the states sometimes in collaboration and sometimes with states working with each other in terms of doing privacy enforcement work, as well as the parallel work of private rights of action being a complement to also hold companies accountable when there have been, compliance concerns. So the Attorney General, in terms of legally speaking, he is a constitutional officer within the state of California. He is the chief law enforcer. Typically, he is elected. However, Javier Becerra was initially appointed to fill the seat of then Senator Kamala Harris, that was left by then Attorney General Kamala Harris when she became a senator. So this is going to be a little bit of a jigsaw puzzle for folks for a minute. So when Kamala Harris ran for Senate, her seat opened up, and that meant that the Attorney General position opened up, and the governor appointed an Attorney General, which is Javier Becerra, and then he was reelected by the voters. Mr. Becerra is now the HHS designate for President Biden, and so once again, if he is confirmed, there will be another governor appointment for the head of the Attorney General's office. And so what has become a very important role in terms of protecting consumers and doing a whole host of law enforcement work has been the attorneys general, in particular in California. Javier Becerra has been very committed to enforcing privacy rights. He's also been very vocal about it. And the privacy enforcement unit, the unit that I lead, was actually founded by Madam President Kamala Harris. And so California has a very rich history of doing privacy enforcement work. We also have many laws as well. As a state, we have significant number of privacy laws that we enforce, and we also enforce federal laws in conjunction with our states. So there's a lot of work for us to do, and as Jared pointed out, our resources are not as we don't have the same people power as the FTC, for example. We're a smaller group, but we work. There's a team, and we have expanded since CCPA was passed, and so we're growing. And now with a new agency that's going to be coming on board, which will proceed with doing administrative law enforcement, the thing that I find really exciting about California's role in the Attorney General's office is that we still can enforce both CCPA for the next 2 years, as well as CPRA in terms of doing broad-based affirmative impact litigation, which was typically the role that we have always been in. The powers of the Attorney General are particularly broad. We have a very broad investigative power. I spoke about that briefly before, but in the course of conducting investigations, we can issue subpoenas and take witness testimony, and all of that type of investigative work is confidential under our state law. We also have the power to, bring an enforcement action, and whether that is filing a lawsuit against a company and litigating that lawsuit in court, or trying to negotiate a final judgment with the company. That is another tool that we have. And in California, CCPA has a pretty significant financial exposure for a company that violates the law. That's $2,500 per violation. And although it's different than GDPR's, 4% up to 4% annual revenue, if you start calculating each violation, it's not there's case law which supports the argument that it's not just a violation. Like, each time there's a violation of law that's a violation, it could even be as high as, for each consumer that who had their rights violated, counts as a separate violation. And so, that is a fairly impactful stick that helps us negotiate with companies, because there is a significant risk in terms of litigating a case. And then in addition to that, the Attorney General is responsible for doing consumer education, which we take seriously, and we try to do that as well. That's really where the Attorney General sits. I spoke a little bit about, how the Attorney General will maintain civil enforcement authority. In addition to that, under CPRA, what I think is of note is that the Attorney General will be able to tell the agency to stay an investigation or litigation of a company. And so I think what that does is it maintains a bit of the ability of the Attorney General to proceed with some of the most complex and large cases that have the greatest impact over the state of California and its consumers. And then just for a minute, I want to touch on what Jared was saying regarding some of the challenges with a federal privacy bill. I think that, my boss, Javier Becerra, has testified before Jared's committee, I believe the Senate Commerce Committee, back when they were discussing what some of the federal privacy laws nuances and areas of tension could look like. But I do think that the state attorneys general, they maintain a very important role in enforcing law. They maintain a role for enforcing federal law, and they are also able to maintain a role in enforcing laws that build upon a floor that Congress establishes, which is why, another area that I might have missed, but that is very important when considering if there would ever be a federal privacy law is how it would play in terms of preempting any state laws. And so, in my opinion, I think that the model that works best is to allow the federal government to set a floor for data privacy, but then allow states to also pass laws that build on that floor and perhaps provide more protections for consumers. Most recently, one of the non-CCPA cases that had made the news that my office filed was against a app developer named Glow, which had some significant data security concerns. Glow is a fertility app, and so users, including predominantly women, were storing very personal information within this fertility app involving sexual health and reproductive health. And it was determined that Glow had some insufficient security practices, and we filed a case under our Confidentiality of Medical Information Act, which is our health privacy law that builds upon the floor that was set by the federal privacy law, HIPAA. And so allowing states to have that type of agility and sometimes creativity to look at legislating in areas where the federal government has not addressed, I think is a really important balance and complement to the work that's being done at the federal level.
Thank you so much for that that detailed overview. And in the last 5 minutes that we have, I will ask both Lydia and Jared to look a bit into the future. And sorry. Oh, I thought it was up until past. Okay, I was just told that we don't have 5 minutes anymore, but just in percentage, Jared and then Lydia, what chances do we have to see federal privacy law in the next 2 years?
Can I give you two answers?
Yes.
And this isn't fair. 100% and 0%. It could go either way. I have no idea.
Thank you so much. And Lydia?
Makes total sense to me. I think those have been the odds for a long time, and I don't see anything changing those odds.
Thank you all. Thank you so much for navigating this complex topic, and in such a shaky tech environment. You've been heroes, and thank you to the audience. And let's keep the conversation going.
Thank you.